Alan is on, okay. All right, good evening, and welcome to tonight's installment of the Daniel Webster Debate Series. As I'm sure many of you know at this point, the series is named in honor of Daniel Webster, one of our nation's greatest orators, public servants, and constitutional advocates. Founded just last year, the series has quickly become the heartbeat of our chapter and a cornerstone of serious legal and public policy conversation here in the nation's capital. By bringing together leading judges, scholars, and practitioners from across the country, we aim to engage in the most pressing constitutional questions of our time with rigor, clarity, and genuine intellectual exchange. Tonight's resolution, a little different. Does artificial intelligence threaten the legal profession? This question has emerged as one of the most consequential and rapidly developing issues facing the legal field. There is no doubt that generative AI and research tools have already begun to reshape how lawyers, and even law students, do their work. And these developments have prompted both excitement and concern across the profession. To examine this increasingly important issue, it is my great honor to welcome two outstanding practitioners who have been deeply engaged in this conversation, as well as Judge John Nalbandian, who will serve as tonight's moderator. Without further ado, please join me in welcoming our Director of Debates, Louis Fong, who will formally introduce our three distinguished panelists. Thank you so much.
Thank you all for coming. Judge John B. Nalbandian serves as United States Circuit Judge on the U.S. Court of Appeals for the Sixth Circuit. He was nominated by President Donald J. Trump and confirmed in 2018. Prior to his appointment, Judge Nalbandian was a partner in the litigation practice group at Taft, Stettinius & Hollister in Cincinnati, where he led the firm's appellate practice and handled complex litigation in state and federal courts. He earned his Bachelor's of Science, magna cum laude, from the Wharton School of the University of Pennsylvania and his J.D. from the University of Virginia School of Law. Jack Kiefaber is an attorney at Jones Day in the firm's Washington, D.C. office. He serves as an adjunct professor at Antonin Scalia Law School, where he teaches a course on AI and legal philosophy. He received his B.A. summa cum laude from the University of Notre Dame and his J.D. cum laude from Harvard Law School. Kyle Singhal is a partner at Hopwood Singhal PLLC. His practice focuses on federal appellate litigation, sentencing mitigation, and post-conviction matters, including First Step Act and clemency cases. He earned his law degree with highest honors from the George Washington University Law School. After graduation, he worked for the Mid-Atlantic Innocence Project in Washington, D.C., advocating on behalf of wrongfully convicted individuals. And with that, I welcome tonight's debate.
Thank you. Thank you all. Thank you to the Georgetown Federal Society for inviting me, for inviting us here for this debate. Before I moved to Cincinnati, I was actually an associate here in D.C. at Jones Day, actually. I was at the firm when the firm moved from over by the old Eva Grill to the building it's in now. And I used to do, whenever I had international law research to do, I used to come here. Well, I had to use the books because we didn't have AI and even then we had electronic research. Of course, I'm not that old. A lot of the old international sources weren't available, so I used to come here and do my research. So I built a lot of hours in this complex. Anyway, I want to begin tonight with not with a prediction, but with a fact, and that is the debate that we're about to have. I think would have seemed like science fiction 10, maybe 5 years ago, and today it's a live question that practicing lawyers, bar associations, courts, and I suspect with particular urgency, law students carrying six-figure debt are asking in earnest. And I'll come back to that in a moment. Now, not long ago, and I'm sure you all have heard these stories, a pair of attorneys in our court filed a brief that cited more than half a dozen cases in support of their client's position. The cases were well chosen, the citations were properly formatted, and the legal propositions they stood for were entirely plausible. There was only one problem, of course, the cases didn't exist. They had been generated by an AI tool, and neither lawyer had bothered to verify them. Now, our court sanctioned both attorneys, and actually fairly harshly as those sanctions have been going. Now, the episode's a cautionary tale, and unfortunately one that we've seen over and over. And I suppose it dramatizes perhaps better than any hypothetical could that AI in the law is not a theoretical concern. It's already here, of course. It's already in courtrooms and it's already causing real consequences. So the question tonight is not whether AI will somehow and someday affect the legal profession. It already has. The question is what to make of that, whether it represents a genuine threat or whether threat is the wrong frame entirely. And that question, I think, lands differently depending on who's asking it. For a senior partner at an established firm, it may look like a practice management challenge. For a public defender's office drowning in caseload, it may look like a lifeline. For a solo practitioner in a rural county handling wills and small business matters, it may look like an existential competitor. And for the people in this room, you all, who have invested 2 or 3 years of your lives, let's be honest, and a fair amount of money into becoming lawyers, it may look like a question about whether that investment is going to pay off in the way that you had planned when you enrolled. And I'm not trying to be cynical here, it's just an honest question. It's part of what makes this debate serious. The legal profession, of course, is not like most professions because it's constitutionally embedded in a way that most are not. The Sixth Amendment guarantees counsel, due process requires meaningful access to justice, courts are the institution of last resort for the vindication of rights. What disrupts the legal profession, therefore, has consequences that ripple well beyond any individual lawyer's career, consequences for clients, for courts, and for the rule of law itself. So on the one hand, AI could pose a genuine threat, displacing practitioners, introducing perhaps new failure modes like hallucinations and algorithmic bias, and eroding professional judgment and ethical obligations that make law something more than a sophisticated information retrieval system. On the other hand, threat may be the wrong word entirely. AI may potentially democratize access to legal services and reduce the cost of routine work, but ultimately free lawyers to focus on the kind of high judgment, high stakes advocacy that no algorithm could replace. These arguments deserve a serious hearing, and fortunately, I do not have to weigh in substantively on them at all. We've got these two. So our format, as you all know, will have some opening statements, and then we'll talk amongst ourselves. We'll have rebuttals, and then talks amongst ourselves, and obviously we're going to take questions. So I think, Jack, are you going to start us off?
I guess that's me, and I know what's going on here, by the way. I've done one-on-one debates against both of these guys. It's clear that unable to defeat me solo, they've teamed up. I know he's calling himself the moderator. I've seen the way he fights. This is going to be 2 versus 1 very, very quickly. So we'll see what happens with this. Is it going to threaten the legal field? Yeah. Yeah, it is, because a lot of people try to argue as though law is this uniquely unautomatable thing. I think it might actually be the single most automatable field there is. And I'll tell you exactly why. I'll do with this little thought experiment. Who here likes blue booking? You love it. You live for this stuff. It's all, yeah, I knew it would be you. So there's always that guy sitting up front. It's the president half the time, too. Nobody likes blue booking, not even you, Dennis. Give me a break. And I get asked a lot because I'm the AI guy. Hey, Jack, why can't AI do this? And this is kind of outdated a bit because it actually kind of can now with Claude Legal. Let's pretend it can't. Why couldn't it? And I didn't know. I don't really know how AI works as a technical matter. It's in a black box. So I asked my buddy on the Harvard Law Review. They make the blue book. They own the rights to it and all that. I said, well, I can't do it. And I said, well, Jack, 99% doesn't cut it here at the Harvard Law Review, 99% accuracy. That's because blue books, law reviews demand exact italics, precise spacing, the correct little abbreviations of the law reviews, the L.Rev, whatever Georgetown is, G.Town, whatever. That's all got to be precise. And he says because LLMs, those are predictable based, but blue booking, that's adversarial. It's got to be the stupidest email I've ever received, and I think everybody here can tell why that is. God didn't hand the blue book down to Moses on stone tablets. We can imagine, I do this with the hands a lot. If this is Doctor.ai, he's rolling, he's seen me do this a bunch of times. Yeah, if the bot's only here, I think it's probably got to get good enough to hear. Because the stuff that makes you sick and well and live and die, like, that's not changing. You can't patch that. But if here's the blue book, and AI is only here, maybe we have to wait for it to get so superhuman and Herculean that it can accomplish the task of exact spacing. Or call me crazy, we can just do this. We can bring the Blue Book down to where the bot is. And Harvard Law Review made a new Blue Book recently. They wrote some article about all the changes. The Oxford comma was a hot topic of discussion. You might remember it on LinkedIn, all the worst people you know, insufferable posting about this. None of the stuff that actually made it un-AIable got changed. That's insane, because we all prefer to not have to mess with it. And my whole spiel that he's heard a million times, the judge too, I can say that entire spiel again, and I will, but I'm going to take out the word Blue Book, and I'm going to say the word law. Because especially in a place like this where we have one of them establishment clauses, law is not handed down on stone tablets to Moses either. We made the stuff up. Even at the highest level, we got Article 5, the only clause of the Constitution that really governs you in all cases. If you wanted this to be North Korea, a fascist dictatorship tomorrow, you just have to check the right process boxes and it all changes. Such that if you wanted the state to be built around artificial intelligence, it's not that you couldn't do that. Why would you want to? And just for a show of hands in this room, who's a textualist in the room? Show of hands. You know, all right, I've been to places. Is that a hand? Is that a hand from the learned? There he is.
All right, now you got 12.
You guys are also in the audience for this portion of it. I did this at Patrick Henry College one time, which has a FedSoc, believe it or not. Nobody raised their hand. Very strange. These young Zoomers, something off there. I think the textualists ought to kind of like this because, for one, you know, nobody's ever litigated. No 34-year-old. I challenge you to find me this case where a 34-year-old goes to the Supreme Court saying, I want to be the president of the United States. And the Constitution has been improperly interpreted saying I can't. Nobody does that. 35 is 35. It's math. It's in the Hall of Fame of laws. Nobody's ever contested that part of the Constitution. We have jobs because of that word reasonable. Stuff like that, right? When there's reasonable in a statute, what do? We've all done legal research memos before. What do we do about reasonable? Well, we get a bunch of documents. We go text, history, and tradition. 3 levels deep, and the text's never good enough because it says reasonably. Trillions of different fact patterns contained in that one word, whatever it might appear. We have to get a bunch of stuff, put it in the thing. All the historical documents, all the documents evincing tradition. That's the same thing as history, by the way. I don't know why they have both of them. Put it all there. Now, what do? We've been here. You Control F. You hit the Control, you hit the F, and you type in stuff. Stuff that sounds like what you're looking for, reasonably. Oh, there's a guy using it. There's a guy using it. And you do that for 7 hours, and you email the partner, here's what I found. Well, I'm no genius on AI, but that is kind of literally what it does. Use Harvey at your workplace or Claude Legal. What do? You build a big-ass vault full of stuff. You put all the stuff in there, and you ask Harvey what's in there. And when I clerked for Kevin Newsom, he basically realized that ChatGPT was that, but the vault was the entire internet. And he thought, well, heck, that sounds like a textualist dream. You know, it's the median usage on a place where everybody's talking. So he used that to determine the word, meaning of a word in a case, and the whole world went insane over that, but he kind of stopped there. I don't know. You've heard of the flagellation thesis, right? If you're textualist enough, the Congress will start writing better and more precise laws. Well, I don't know how a textualist argues against this. What if you had a new type of language, you know, where you basically just defer to a bot. You say, whatever that bot defines these words at median, it's right. You just put a pin in it. At some level, it doesn't exactly matter what's reasonable. I'd just rather know in advance. We're going to take the median language. I always ask the class I teach, that Tate over there is in, at GMU, do you need to enumerate a dictionary first to really have a textualist system? Is that the first law you need to pass? The dictionary? Enumerate Black's Law Dictionary, enumerate Brian Garner, make those all part of your statutory regime? Well, this is how you could basically do that in reverse. Whatever this bot says the words mean, it's right. It's corpus linguistics, but it works in every case. Because even if they has to pull out a coin and flip it in certain instances, it can do that and at least decides on something. What happens when you have that language? Well, one, Congress can write in that language. You know, nobody runs Microsoft Word on poetry. You get a lot of error screens. They run it on binary code. There are languages mathematical enough that exist that you can be mathematically textualist about them, Bostock style, right? What if Congress just wrote in that language such that, yeah, you've got a judge, but he's kind of a janitor on the spotless floor. You know, he's walking around with his mop, he's employed, but there's nothing for him to do. Floor's clean, he can see his reflection in it. What could you get in that case? Well, you get advisory opinions. And this is why this stuff is a threat. And it's a threat whether you make this stuff enshrined in the state or you don't. Let's say you make Judge.ai top down. You could do this for your contract too, by the way, private pocket Leviathan. But let's say America throws the Constitution out the window, does this. Well, now you can ask the thing in advance. Well, hey, can I take my toy car into the park? Statute says no vehicles in the park. And earlier, I don't even know if he had a statute. You might just have a chatbot. It You talk to the law. And the law, Kyle, the law would tell you, no, that's a toy car. It's a little tiny guy could go in the car. He could drive the car around. That's a vehicle. You can't take it in. That's stupid. That's ridiculous. I can't believe that's the case. One thing you wouldn't do is take your car in the park. You would have perfect knowledge on the front end, and there's nothing you could really do with the quote-unquote judiciary. You didn't just get a legal opinion. It's not an opinion. It is the law. The law talks to you. So what can you do? Well, the only thing the Federal Society's ever wanted you to do, petition the legislature, which is, of course, the guy who patches the machine. And, of course, you've seen the tweet, AI can't replace the lawyer because AI can't play golf with the judge. Funny? Not really. That's kind of true. You need to be able to relate to a human judge. But if that judge is a robot, that's where all of you guys depart the picture, because now there is no more reasonably to parse. I think that's a textualist utopia, and we can fight about that, but that's not the debate. Is it a threat? You might be saying, well, Jack, nobody's ever going to sign on to that at grand scale, because I'm not going to save him the trouble. He always does the show of hands. Nobody thinks it's a utopia, and I don't know if I do either. But I'm going to close with this. The future of law. My buddy made this thing called LexHub. What does that do? It's a predictor. You know the Red Rup case, where they didn't want to say what porn was, so they just started saying affirm, deny, 0, 1. The Supreme Court started talking in a binary language. Well, every opinion basically culminates in that. They've got explanations, but they all have affirm, deny. This thing eats 2 briefs off pastries, paying the money, buy a ton of briefs. And it makes correlations. It's a classifier, barely even an AI. It classifies these 2 briefs, that's a fact. And that fact goes in this bucket. And that bucket tends to correlate to affirm in these cases. And it makes these predictions. It's about 95% accurate on the D.C. Circuit. 98 on the tax court. He's actually got guys betting on this thing now. It's paywall. I'll get you a private account if you really want to see it. Well, that's a pretty interesting model. That's kind of hallucination proof because it's tethered to actual items. Now you actually do have one of these, and the bot can train up and hit it. And when it hits that, what is it doing? Well, it's made of 0s and 1s, black box enumeration of judicial consciousness, which, to be clear, is the only law that's ever ruled you. What the judge thinks and what all the various judges think at scale combined together, that's the real law. So that's a good predictor bot to have. There's another thing, too. I was going to have it write a paper for you all on the spot, but I got bored with the idea. It's a thing called the NIBot. It's trained off of academic prose. Same guy built it. And it'll write you a law review from scratch. Perfectly blue booked, and Claude Legal's got this stuff whipped now. It's a Claude wrapper. Blue books it. Sites are all good. It'll write something in your voice. I can picture a combination of these 2 products where you sell privately, would basically you stick your briefs in, because if it can rate 2 actual briefs, it could rate your hypothetical briefs. You could train it on less and less. Now it just needs 1 brief. Now it just needs facts. Now it just needs individual sentences, such as the little chat bot itself. You interact with it. It rates your claim. It tells you if you're going to win. Maybe even tells you who's going to concur and who's going to dissent. And using a little NIBot tech trained on their voice, it writes their opinion. It writes Judge Nalbandian's opinion for him in his voice. If he's got a stressed law clerk, I know a few of his current clerks, I imagine they're pretty stressed. Playing too much Mario Kart all the time, and they should be writing them opinions. Might be behind the game. They know there's a website over there that's got their opinion pre-written. Kind of seems like Judge.ai exists privately. That's something I would, if I'm a client, I'd like to use. And this is not fiction, by the way. Learned Hand, my buddy Shlomo Clapper's got a business. They just sold this judicial aid tool to all the Los Angeles County Superior Courts. Supreme Court of Michigan's got it too. It advises the judges. And if it gets pretty good and the judge gets kind of bored, he can just start hitting the generate button. I think it might be malpractice if you don't buy a consumer side version of that bot. And then you got lawyers using the same bot the judge gets. Who's the judge in that case? And if you can just ask the judge for the answers, well, then you got your textualist utopia. There's no more ambiguity at all. It's all predictable because you know in advance what there is. And all that remains is what they tell us to do in the society all the time, which is just go to the legislature. And maybe that's a form of lawyering that continues. You get 2 parallel jobs. One guy has to argue about policy making, lobbying style. The other guy is just a professor who queries new loopholes into the bot nonstop. What about this? What about this? What about this? And tries to plug them that way. Sort of that's how you replicate your ex post amendments to laws that judges do now. But it all happens on the front end. I think that's textualist utopia. I think it's coming. We can discuss how it's going to radically alter practice. The way it lets you price facts. The way it lets you trade them like assets. The way it makes everything into ambulance chasing, because as lawyering gets homogenized by the bot, it kind of just matters what's your business. Do you hold the winning facts because the facts win the case? I think all that's coming down the line, and yes, dare I say, that is a threat to the legal profession. I think the people who see it that way take that for given and try to build a hypothetical legal practice around that are going to be the ones who do the best, prioritizing the facts, knowing that the outcome is about to get a lot more predictable. Kyle.
Thank you, Jack. All right, so the topic is, does AI threaten the legal profession? And thank you for inviting us and for choosing that topic. It's nice to vary things up a little bit, and I have to respond to the various points that Jack just made and make sure my answer is no, it doesn't. Of course, I have to concede that it will change the landscape. It certainly has already changed the way we communicate. It's wonderful. I haven't had to talk to my wife in months. I can just use Copilot, and it's like qualified immunity for talking. I couldn't possibly really mean something else. I didn't mean what I said in the first place if I didn't draft the words, right? So it's absolutely wonderful. Of course, there's garbage too. You spend all your time producing work product for a client, and then the client says, "Okay, yeah, but ChatGPT said this," and if you were going to chat GPT, what are you paying me for, right? But I teach at a law school across town, and I ask students, "Do you guys use AI?" You sort of get the sheepish response, "Well, I use it for research, but not for writing," which is bullshit. Of course you use it for writing. You just tweak the words here and there so that it's no longer, Claude's writing. And the problem is you might not be using it for research very well because the LLMs, at least Claude, Grok, Gemini, and GPT, aren't plugged into all the case law. And the Westlaw and Lexis and Bloomberg plugins, which are quite good, aren't plugged into how to generate text the way you'd like them to. And maybe you're using Claude Legal or Harvey and you're putting stuff in a vault. But if you're not, if you don't, at a minimum, know how to do all of that, you're in trouble, and you better start now. Now, that doesn't mean I think there's a threat any more than say, the internet posed a threat or email posed a threat to the legal profession. But to build on what the judge said, I mean, you're the ones who have spent 2 or 3 years of your lives and lots of money on your law degree. It's incumbent on you to spur the ROI. So I don't know if your law school is paying for the pro subscription to Claude and all this, but if not, you better go knock on the door and ask them to. I mean, back when I went to law school, Lexis and Westlaw were really, really expensive. It used to be, you'd get billed by the search or by the minute. It's not that way anymore. They'll do custom little plans by the month or whatnot because they know. But it used to be tens of thousands of dollars could be spent in the blink of an eye on Westlaw or Lexis, and it was a luxury to have the law schools pay for, not pay for it, negotiate all that because they have bargaining power. Your law schools have bargaining power. So my pitch to you on that front is to help make this not a threat. Embrace it, learn how it's used, and use the time you have now when you're not billing hours to get your law school to help you learn how AI works. It's here, it's coming, and you need to be able to use it well. The answer shouldn't be, well, I use it for research but not for writing. The answer should be, yeah, of course I use it, and here's how it works, and I can tell you all about it. And your clients want to know. I mean, the clients who, some of them will want to know that you're actually being human. Some of them will want to know that you're being efficient with their money. And so there's no reason you shouldn't be able to answer those questions in a sensible way that's tailored to the client's needs. All right. So is it a threat? I say no more than other things like, let's say, the internet, email, and no more than other delegations like magistrate judges or clerks or paralegals. And so let me unpack each of those. In terms of other technology, I mean, I was a very small child when the internet came out, at least, in the form of Netscape Navigator, where people could use it, not the old, government version. And it's been 30 plus years now, and there are still lawyers out there who are quite successful that don't do their own email, right? That's a dying thing, but it's out there. So I don't think there's a 10-year crisis horizon timeline where it's going to take over the world. I hope that ages well, not poorly, but it's probably a 20 to 50-year timeline where you have to use AI to be able to function in the legal world. Maybe closer to the 20, but none of that means that the industry goes away. It changes the nature of the practice. What we're dealing with, so let's assume Jack's trial by chatbot, advisory opinion by chatbot, really. Why bother having a trial if the chatbot's already told you can't take the car to the park? Let's say that Jack's chatbot universe becomes real. Okay, and so we all live in Blackacre, right? Of course we do. And when you drive into Blackacre, this little gated community, it's a very nice place, and there's a QR code that says, by entering Blackacre, you agree to adjudicate all disputes by chatbot. Here's the QR code. Scan here. Download the app. The chatbot it's built into the app. Here's a phone charger and a bank, so you never have an excuse like you ran out of the battery. You can always just ping the app. That way, before you go into the park with a car, you're unnoticed. I don't know why you wouldn't just hand out Google glasses that tell you in advance you're about to get, drone struck for.
Oh, yeah, you probably would.
Okay, all right. But let's assume we're in the Lon Fuller world of, okay, no vehicles in the park. So what does the task become? I'm in the park. I've got a paper airplane, right? I folded up my paper into a little paper airplane, and I say, chatbot, can I bring a paper airplane into this here park in Blackacre? And the chatbot says, well, let's assume this. Can I take a piece of paper into the park and fold it into something that looks like an airplane, all right? And the chatbot says, sure, it's Blackacre, landed free. Paper? You can bring paper into Blackacre, into the park? No problem. Okay. So I bring my piece of paper in, and I fold it up, and the moment it goes zoom, zoom, the drones come in and detain me. And then the prosecutor, using the exact same chatbot, asks the question, chatbot, can you bring airplanes in the park? No, can you possess airplanes in the park? What if the airplane is made out of a solid-state tree-derived material that we call paper? Well, we just said you can't bring airplanes in the park, death. And so what the obvious currency is, how do you ask the question? And you're seeing that now. You can ask Claude the same thing 3 or 4 different ways and get 3 or 4 different answers. And so you're going to have to know how to ask the question. When the client gives you, here's what ChatGPT said, give me the whole conversation. Let's see what you asked. I'm not going to read what ChatGPT said. I'm going to read the questions you asked it. Let's talk about why those are or are not the right questions. But the premium is going to become, how do you know what questions to ask if we're in that world? And even before we get into that world, you're going to have to figure out how to ask the question so that you can handle the incoming changes. It's not a threat. It's just a change. Email, we used to fax. We don't anymore. We used to go into the courtroom and knock on a window to schedule things. Now we file things online. People adapted. It's no more of a threat than delegations to magistrate judges, clerks, paralegals, other things like that. Now the thing with magistrate judges, I think it's a good analogy to think about a starting point for how we can conceptualize diverting the judicial power from learned judges to chatbots. With a magistrate judge, you've got this idea that, after you've drawn your judge, you and opposing counsel can say, I don't know if we think we'd rather have the magistrate judge. You could do the same thing with chatbot, right? If these courts are going to have, what I perceive will happen is you'll have 2 tracks. You've got some small claims. Look, you got a $4,000 claim, the people that sold you the grill doesn't work. Are you really going to go to trial over a $4,000 claim? You could. And I suppose the court would offer 2 tracks. You can either have the human judge, we'll have trial in 18 months, here's how that works, or AI can see in 5 minutes, right? And I'm sure people will choose that, and as long as there are the right back-end provisions, the big mystery that we'll have to figure out is Jack's model just gives you the yes or no, right? Even conceded, sometimes it will do a coin flip if the text of the law doesn't fully address. I don't think the chatbot's supposed to be in the construction zone. At least it's not supposed to be legislating. Maybe it's in the construction zone. But theoretically, if it's a textualist utopia, it's just defining and applying. It's not even really construing, right? Let alone expanding the legislation. So there will be times when, rather than expanding, it'll coin flip. One presumes it'll have consistent outcomes, but what we don't know is whether and how it will explain itself, right? Once you go from a classifier system that says these facts mean yes or no to generative AI that's giving you the text, we need to know more in order to be able to provide informed consent to that. I think that any model that allows courts to delegate decision-making to AI has to have informed consent built in, and it has to allow the public to have the same access that the courts have. Why not? I have to have the public-facing, version of it. I have to be able to ask the same questions it's going to ask. And I'd like to know that we're going to be able to see what questions, internally might be asked of the chatbot by any humans in the court. I would propose that we're going to have delegations to chatbots, some sort of governing regulatory or advisory body for transparency. I don't like the idea of governing, regulatory and advisory bodies. I also don't like the idea of trial by chatbot. Note if we're going to have it, the big problem right now is that the code is proprietary. Jack conceded it's a black box. I'm sure he's got a financial interest in all this. I don't know that he knows how the code works. So he's hoping that the code works the way he thinks it works. But the fact that it's proprietary is a problem, and it needs to be be transparent. Whether that means we, when we're amending the Constitution, we just expropriate all of this or something else, I don't know. But it would be great for there to be some sort of public collaboration with the, I think, good market forces that are now causing AI to excel. All right, so no more of a threat than other things. Jack's argument, my second sort of set of points, is that it presumes that AI is, I think, better, faster, and cheaper. At least the argument that it's a threat presumes that AI is better, faster, and cheaper. And I think all of those are at least short-sighted as of 2026. It assumes, let's start with better, that AI is in fact better, or at least that people will accept the minimally competent workflow that it produces. I'm not sure that's right. In these smaller cases, yeah, should we automate the 2 million case backlog of Medicare, Medicaid claims? Why not? Or at least provide an option. But humans that are facing prison time want to look you in the eye and know whether everything is going to be okay. And as long as we have, incarceration as a punishment for bad things, people aren't checking the chatbot every time they walk into the park with a paper airplane. People are going to be facing prison time and want a person, not ChatGPT, to be the source of comfort. Is that to say they're not also going to go to chat? No, they will. It's happening. But I'm not convinced that people will accept AI in that context. You already see there's something in the Atlantic Today, Backlash, and the New York Times, whatever, some Dear Abby kind of article being, it wasn't even the article, it's like a letter from a person being AI sloth. There's pushback. There are people who value words that are going to push back at the quality of AI's words. I think an analogy here is self-driving cars. It's things have, thankfully, they're slowed down. I like driving real cars, but when it was the big push maybe 5 to 8 years ago. Look, we're going to go from 30,000 road deaths a year to 300. Great. If the 300 are a subset of the 30,000. No one's asking that. No one's figuring that out, right? 99% reduction in road deaths is a wonderful idea, except if the 300 who are going to be killed by self-driven cars are sort of seemingly at random when the AI doesn't spot that the truck is white and drives into it, whereas the 30,000 might not be all avoidable, but I, as a skilled driver who's been, I can navigate around, I'd rather take my odds with the 30,000 than have random, where it's 1%. Maybe you wouldn't. Maybe 99% of Americans would think otherwise. But as long as it's that, as long as the 300 are not a subset of the 30,000, then it's a trolley problem. And trolley problems should be solved by legislatures, not by financially driven coders or their proxies. So, that's it presumes that it's better. It might not be, and people will push back. Is it faster? And obviously, in some things, yes. If you give it 2,000 pages and say, please write me a book report, it will write you a delightful book report in sort of that AI slot gloss on an 8th grade level. Again, assuming you are fine with the competence level. But the problem, if we're going to replace judging with the chatbot, is then you've got cases where it produces normatively unacceptable answers. And then Jack's solution is, well, you can just petition the legislature on the back end. We've plugged the law into the chatbot. The chatbot says go to prison. Go to prison then. How long is it going to take to petition the legislature? Is that a years-long process? Who gets to lobby? Do you get to lobby? There are problems there, and I'm not sure that as a systemic replacement, it's net faster. Is it cheaper? I think AI is lying to us about how cheaply it gets things done. I don't know that these hallucinations. It's just bad lawyering, right? It's people who can't even be bothered to check the work of the AI. But the fact of hallucinations isn't a problem in that we know they're there. You can, if you beat Claude well enough, it'll give you what you want. It'll just not put the cases in there. But I think the fact that it's still doing it is reflective of a cost problem. If it were to run every single process that you would want it to run to give you perfect output the first time, that would take a lot more energy than if it gave you minimally competent workflow. So it's not going to give you a perfect product. It's going to give you something that it thinks you'll accept. The people that are investing in data processing centers and kilowatt hours are not, it's just prospecting. They're out there hoping to drop some venture capital money and make a 10x return. That's not a sign that this is actually going to be a boon that goes as planned. So I'm not confident that the efficiency is there either in terms of speed or cost. I think we'll see, but I think it's something that, as with other tech like Uber, might take a very long time in order to be both good and profitable. I'll end for now with this, which is I would say of the textualists in here, but we'll just say of everyone, which of the following is better? Option 1 will be trial by chatbot, and option 2 will be trials by humans with judges and juries. Who wants trial by chatbot? All right, who wants trial by humans? All right, so by about 12 to 1, Jack loses again. Rebuttal, sir?
Do I rebuttal? You going? I mean, I'll take these in reverse. There's a lot of stuff here. He always brings out the hallucinations point on me. It hallucinates not because it's too hard, and this is kind of a cynical point about the law. It hallucinates because Westlaw is paywalled. You'll notice that when you put a bunch of stuff in a Harvey vault, it's actually really good at telling you what's in the Harvey vault and what the page numbers are and all the various things. And even Claude Legal Now has radically decreased the hallucinations, but not because it went and found the stuff, because it just got better at admitting when it didn't know. It stopped trying to impress you. You should take that to heart, that, Pacer, Westlaw, these guys are holding on to their data sets, guarding it jealously. I wonder why. What are they afraid of if they just let all the cases out there where the public should, in theory, have rightful access to them? It's almost as if they want some kind of artificial moat between the profession and the bots. Now, you get also to the, is it faster? I don't know. Everything you talked about, what comes at the work, to me was the policy process, There's knowing what it is. And isn't that, Dennis, what are the 3 principles? Number 3, to say what the law is and not what it should be. There's a lot of extra of what the law should be, obviously, and that takes a long time. That's sort of mankind's highest order endeavor to find that out. What the law is, the problem with our system now is we have to wait decades, in some cases, to learn what it is. Then and only then can we debate what it should be. And I think that's always the hand-wringing we're going to have. What should it be? And yeah, there's a reason Congress moves slow today. Would this system where you just know it empirically speed it up? I think undoubtedly. And is it better? I don't know. Everything Kyle reaches for that the lawyer really needs to do, it's not clerical. It's the consoler-in-chief. I want that human experience. I'm racking my brain for the class I took in law school on how to be a more empathetic and consoling human. I think I missed that day. Maybe, Kyle, this is what you teach.
That's why your future's not bright, Jack.
And did you take that class in law school, Kyle? The bedside manner class?
Should have gone to Yale.
That's all they teach at Yale. Jeez. Maybe that's when I was more of a black letter guy. And if we're admitting, well, Jack, turns out black letter was not what you should have been taking. It was these softer things. That seems like kind of a threat to me. I don't think it takes 3 years to learn consolation. It might not even take a law degree. And I'll very readily admit, the stuff I do at Jones Day, I've never once felt like I needed a law degree to do half of this stuff. At least of all the client-facing. That's on-the-job training. Going back down, sort of AI as magistrate. You talk about replacing the construction zone. Yes, it does. And there's this whole thing of, there's the black box. I don't know what it is. It gives an opinion. For one, I don't know what the judge is thinking either. He writes me an opinion, but hell, so does the bot. I don't know if the judge really meant what he put down, the inscrutable mind up there. So I'm not sure if that goes away. How does the textualist explain himself is the question. It's like you say, Dad, can I go to the park today? He says, no, you cannot. And you say, why? He goes, because I said. And you say, well, no, that's bad. That's what the bot's saying. We can't do that. Because I said, that's what my daddy said to me. Because I said, he'd say it real stern. What does the textualist say? The textualist says, well, let's look at the words I used. You, that's you, can't, that means you cannot, and go to the park, that's what you want to do. Let's refer back to the can't. Turns out you can't go to the park. Like, fuck you, Dad. What are you talking about? It's the same thing. You're pulling my leg here. This is like what I don't know. I think my dad was being a little smarmy if he gave me that result. I think it's just kind of a longer, more costly red replication with a lot more citations. I got eyes. I can read. And if we're doing math, let's just make it math anyway. Then the last thing, what happens when, how do you prompt the bot, he's saying? Well, what do we do right now when we want to go into the park? Well, we ask our lawyer. And for one, how do you prompt your lawyer? Maybe you don't ask him the right stuff. And then the answer you get back to your improper query, it's not even what the law would say if your query was correct. It's what a guy thinks it is. You might start a business someday, and I've started a few, and you have to call a lawyer. And in a lot of cases, he'll have gone to a really bad law school. And you go, wait a minute, I spent all the money to go to a good one. Why do I need this guy? Well, it's because the insurance company doesn't care what you think. It's, the one who represents himself as a fool for a client. That's a crazy quote. I'm a fool for relying on my $250,000 education? But the real secret is nobody knows. Even the learned judge here doesn't know what the words mean. His vote counts for 1 out of 3, and really out of a lot more when you factor in en banc and you factor in the learned Supreme Court. That's the most what you get. You still have a prompting problem with the human lawyer, but you're just in this flesh and bone blood machine that's just kind of guessing. Maybe. And maybe if we wait long enough, we'll get a long, robust line of case law on this particular reasonably in the new statute. And 20 years from now, we'll kind of know what it means. At that point, I'd rather just know the thing up front. And I think Kyle's underestimating how many things people would ask this stuff up front. I don't know if that's a good society. Might be kind of a bug man society I don't want to live in. But I think you'd ask this thing before you did damn near anything. Especially with high dollar deals on the line. You're imagining that people wake up one day and their contract is governed by a bot. I imagine where people can ask the contract what's going to do before they sign the contract. I think people would vastly prefer to never be in court for the $1 billion deal in the first place.
Jack, you've used 5 of your 2 minutes.
Yeah, I've used 5. Will you come back?
I'll come back and use 1 of mine, and then we'll let the judge chime in here. I'll say one thing, which is there's a difference between what Jack is conflating is saying what the law is and saying what the law is. In the sense of the Federalist Papers, it's saying what the law is
ladies and gentlemen.
Versus I was not Bill Clinton's lawyer. What the law is in the text versus what you think it ought to be instead. In the sense of saying what the law is, in the context of criminal law, which I guess you didn't have at the Harvard Law School, but I did. We have these things called adverbs, knowingly, purposefully, recklessly. They have definitions. And Jack says that's a problem, but those are words that we have in the statutes that have meanings that we let juries decide the application of. All right, and so that all I will say is we have a human system where just like you started with, you don't want to bring Doctor.ai, to the medical field. I think that solving human legal problems with humans is as important as solving human medical problems with humans.
I know how Kyle thinks. There's an objective.
You don't get a rebuttal.
And natural lawyer Kyle Singhal. I know you think that, Judge.
I think that for sure.
I know you think
You
that.
are a radical positivist and very dangerous.
Well, I'm good with that. There's no doubt about that.
Gotta do something to stop it.
Julian and Kyle.
You're a trolley switch guy, or run him over.
All right, let me ask you guys a question and then I'll open it up. One of the things that Kyle said, and I think you would agree with him, that at least in the immediate future, and even in your world, I think there will be a skill with prompting, with questions.
Yeah.
And that's something we see now when I use Claude. It's a dialogue, right? And if you're doing a legal problem, you're probing question. What about this evidence? What if I told you this, or let me upload a transcript or whatever? And there's obviously some legal training and experience that goes into kind of teasing out the answer or the reasoning that you're getting from the model. And what I'm curious about is, for me, obviously I've been a lawyer and a judge for 30 years, so I have that experience. One of the things that looks like the threat right now is to junior lawyers and the things that junior lawyers do, like due diligence and discovery.
Yeah.
How are we going to make new lawyers who can prompt and reason when we are taking away the tasks of the junior lawyers?
Do you want me to answer that first?
Yeah, take up.
There was something on Law 360 today about firm fired associates replaced with AI and is doing great. I see no reason why there wouldn't be a shift in the number of first to third year associates you'd have doing that kind of corporate work. You shouldn't need as many humans doing the digging through documents. You still need humans to look at it until we just delegate everything to AI. It's the classic, you mechanize when you need more people, not fewer. It's how technology tends to work. So there might be a threat to someone whose only skill right now as a first-year associate is doing due diligence. That person needs to figure out how to mobilize the next 5 years, perhaps, if they're the bottom person on the totem pole. But if it's you're going to figure out the technology now so that when you go somewhere or go off to the firm, you'll be able to use the tech and not be let go when the firm realizes your only skill is something that's now obsolete.
I mean, hey, you're the prompter, and that's what I am right now. And I get a crazy amount of work done just by cutting and pasting literally what the partner asks me and putting it in, and that's my query. I just had the guy tell me today, Jack, you got to work on your attention to detail a bit, but one thing that's inscrutable is your writing. And I know a lot of these guys are using Harvey a lot, but your writing's really strong, and I just don't think Harvey's up to that yet. I didn't have the heart to tell him I've Harvey'd every deliverable, basically to the word, for the last 4 months. Harvey's written every single thing. You know, he gave me a lot of red lines the first day, and that was the last time my human brain entered the loop. He doesn't know yet. Nobody tell him. I won't tell you his name. Obviously, you're going to be the prompting gopher, and sure, maybe you got a living on that for a while. But what's nipping at your heels is the question. This classifier model, we didn't really talk about this. LLMs, they hallucinate a little bit because they're trying to guess the next token, but the bot really wants a thing that is just classifying, here's a fact, and it's like this other fact, and it results in win or lose. And that's what they're going to be trying to do behind your backs. While you're learning to prompt, they're going to be building models that are much better at taking small amounts of facts and either asking you to flesh them out or putting them in the right buckets that then correspond to the results, such that it can look at a very large data set and basically, within a statistical confidence interval, get you in the right area. So, I mean, I don't think it's just a problem that's going to last forever, that prompting is going to be variable. It wouldn't be weird if that was the case. I think that there are patterns between facts. That's why every cold call starts out Kingsfield style. What are the facts, Mr. Hart? That whole thing. We know that. There's a quotient of facts, and there's certain parallels between them. That's what these bots do. They find parallels. They find analogies. And as that gets better, you're going to have to prove fewer and fewer and fewer facts until basically it takes over its own property. Oh, you said this? Did you mean this? Oh, you didn't? Are you sure? Maybe you meant these 10 other things. And if you want to win the case, maybe you should prove this one up, wink, nod. That sort of thing, help you shape your case in that way. I think the bots will be doing their own prompting very shortly.
Great. Questions from the audience?
We usually have a couple. Yes, Dennis?
Yeah, so at least litigation, isn't all law just making the two best arguments for both sides, right? And a neutral arbitrator kind of deciding which argument is better, right? I mean, AI can just make a good brief for party A and make a great brief for party B, and there's going to be a judge that decides which one is a stronger argument. And then if it's as judge.ai decides party A has a better argument, you need professors, lawyers, and judges to say, no, that was wrong. And then there's arguments, debates. That seems like just the legal profession right now anyway, with another added element.
Well, Tate and I actually got into this in class recently. Remember this? Subjectivism versus objectivism. There are two ways to view the world. And there's one world under which I am totally cooked, I'll admit. It's the world that says, well, there's not really right answers about anything. There is just the most aesthetic and platonically pleasing argument, the most persuasive argument on either side. This is how the debating champion sees the world. This is the Ted Cruz view of the law. You have two briefs, red and blue, and that basically, you've heard of this, AI will be superhumanly persuasive. So you'll need to get your really good Kirkland bot, will go get the really good Jones Day bot, and then they'll go to the top. Even if you get that, where you've got Iron Dome going against nukes, it's perfect on the way out, something still has to pick which one. If we're in this floating cosmic soup of, geez, they're both perfect, and I don't know what to do, and that happens to every possible thing, well, now somebody is literally tossing coins. I don't know, we just got to pick one. We'll contrive an objectivity. So I guess I still win. But there's also the objectivist view, which is that, no, it's not really about the arguments. The facts win the case. I think the actual common man would hate the idea that, what do you mean the better looking, the better sounding, the better writing lawyer wins the case? Shouldn't the winning facts win the case? I think that's kind of where that would be going. If that's the case, then you're not even looking at the briefs. And when I was on the 11th Circuit, we watched some bad oralists. They won a lot. Why'd they win? Well, because the good judge, and you've been in these shoes, he can't brief the thing worth a damn, and you go, well, I guess I've got to go become his lawyer. Party presentation principles are really the only thing standing in your way on that.
Right. I mean, the adversarial system is designed to get at the right answer. There is a right answer usually.
Right. I think objectivity is the way to view it.
And so the better brief doesn't always win because they're not correct. Yeah. It's a better brief. It's well written. And I think judges struggle with how much do I bend over backward to, I don't want to be seen as helping one side or the other, but I don't want to get the law wrong. And so it may be that the advocate, Jack's exactly right. And Kyle probably had this experience too when he clerked. We get back, you go to the oral argument, you get back to chambers of, wow, that guy was terrible. Oh, he's going to win. Yeah. He's going to put on his website that he won he got a Sixth Circuit reversal of a criminal conviction and going to look like he's the best lawyer in the country. In reality, he was terrible and his client won despite him. But that's kind of where we are.
The problem with it before is that there are facts, right? This goes back to the facts will matter more. Was the light green or red? Well, if you have cameras everywhere, sure. Would a reasonable doctor have failed to diagnose this thing? If you have doctor.ia, maybe that goes away. Did the president doing this thing act in his official capacity? I don't know if that's, at some point, there are facts that a jury has to decide what the facts are. Now, in terms of the law, I think what AI could do is it could look at, it'd be great for summary judgment. Just look at what are the undisputed facts, and is there actually a reason this thing needs to go to trial or not? At that point, you can automate. Why bother having briefing at summary judgment, right?
Right there.
I mean, by maybe appellate litigation could be screwed, but you have, juries are triers of facts. You have to get witness testimony and all these things in there. How could AI possibly do? I mean, that seems like the role of a trial attorney to kind of set that up, to figure out the legal theories, figure out how we're going to try and approach discovery. For an AI bot to actually do that, they're going to have to understand the entire world, even that's not digital.
Oh yeah,
I mean that just seems, maybe it happens, but still you have to persuade a jury. We sold the Seventh Amendment. So
I will never contest that the trial lawyer lives longer in these cases because, what happened? And you're right, the Platonic way to boost inputting, if the state is a machine, such as to take things in and put things out, well, the the appellate's kind of a weird, conversion of input to output. But the input, you have to have just cameras everywhere. You have to have this Platonic state. And that's the reason, Twitter became so draconian pre-Musk. It would just, if you tried to type in the bad word, it wouldn't even let you put it out because it's physics, it knows everything, and there's really no science or component. So you might still have to tease this thing out in front of a jury, and the question becomes, well, what is that jury? And I've seen juries get called and selected. It is this weird flesh and bone machine, and you're kind of LARPing at the end of the day, and it's very policy-based. I think Kyle reveals this interesting impulse, which is sometimes the facts themselves just are policy. You want it to be deferred to 12 people. And maybe that's good in some sense for ex post justice. You want, again, to look that guy in the eye when you've already acted and stumbled into it, but it's terrible for when you're trying to make business decisions on the front end. I don't know what 12 guys are going to say. No lawyer in the country is going to be able to tell me what 12 guys are going to say, and they often just don't decide on the right stuff, which is why the judge can actually take it away from them at the end of the day. Sometimes there is objectivity in fact. So again, if you're looking forward to your legal career, where should you put your focus? I think facts are the whole ballgame. How do I find them? How do I prove them? Either you're investing in cameras, you're investing in things that can reap what the cameras see, various different inputters. Because that state's coming too. Big tech gave everybody one of these, and Musk's investing in all these things. And what do they all want in their pie-in-the-sky goal? They all want this weird metaverse concept where everything you do, and I went to law school, by the way, at 1L on Zoom school. I have been to the metaverse. It's not The Sims. It's every litigable activity I do takes place on a screen. Gen Alpha lives on Fortnite. More and more that's going to take place, and I think that's what they want. The big tech companies have seen the facts thing. They realize that's all that matters, and that's why it's all big data. They want to learn things about the world, and as they learn more, that's where that jury tends to decline, which it already is declining already, I'll admit.
Yeah, you had a hand and you had a hand.
Can I address that for a second? Because I think it's an interesting question about how far we're going to be able to replace kind of the trial level practice. There are a couple things that Jack said. The rise in body cams, for example, on police officer has completely changed civil rights litigation because a lot of those cases now are getting resolved in summary judgment or motion to dismiss. Because there isn't a dispute about the facts. They're literally on the camera. And every 1983 case that involves excessive force it used to be, hey, the cop hit me before he told me something. And yet now it's simply on a camera. And I think that the technology is changing. I saw trial practice changing 10, 15 years ago when I was a lawyer, that a lot of times we were litigating to summary judgment. And we were thinking about the case as a summary judgment case. Because a lot of times the facts aren't actually genuinely in dispute. You have to go find them, but then they're not disputed. Yeah. And so it becomes a summary judgment case. Then you have those few cases that Kyle kind of talked about where a jury's going to get it because even though the facts, negligence is the classic example. was this reasonable or not? Even if we all agree on what the facts are, it was raining, they were going 30 miles an hour, the light was whatever, was it reasonable or not? And our tradition in this country is to give that to a jury to decide whether there was negligence or not. But think about this, the classifier bots could have the data that says that is generally negligence and could give you a decision without having a jury. So I'm not sure. I think you're right. There is some core that is going to be left that we wouldn't be able to give to a bot, but I don't know how big that core is.
We do move with the fact that these things just look at pixels on screen, but what do we look at? How do we tell a guy's lying? We look at his face and we go, I think he's not lying. That's what it does too. You had the hand up and then you back there.
Thank you. I have a question about the objectivity of the hypothesized AI judge. I mean, it's, it seems to me that if we were going to implement an automated judiciary, then we would also have to agree on the parameters and values that this thing would be programmed on. And it seems almost impossible to me, that we would come to some sort of consensus or even find a procedural method by which to reach a consensus, number one. And number two is that, what happens in those cases of, I think it was Gorsuch that says, or maybe it's Breyer, grievous ambiguity, where you do have to go beyond that which is on the page. I mean, is there an established list of canons that we then import to the machine? Do we act like Scalia where we spurn canons but then create our own curated list anyway? It seems almost impossible to me to come up with a way to design this thing that would be agreed upon as objective. Yeah. And if you couldn't, then what are you going to? You're now going to sue the AI judge in an appeals court. It just seems like there's so many complications.
I mean, parameters and values, that's legislating. That's what governance is. How do we define the values of our system? How do we deal with stuff like that? That is legislating. And it is hard. And our legislature doesn't do it anymore. And how do our courts do it now? Well, some of them are Catholics and some of them are Hindus and shit. Like, I don't know how they do it. They just...
Well, they do it in words, and the problem is that the Congress doesn't know how to speak in ones and zeros, and at some point, even if we agree on what the words are supposed to be, someone's got to transform those into ones and zeros, and it's not going to be you, because you don't know the ones and zeros. It's going to be some contractor. And so there's a problem in the inputs of how do you actually, we can all agree, all right, no vehicles, even paper ones in the park. How do we make sure the bot's actually going to do that and not do whatever the bot thinks instead?
Well, there's a question about how do you make sure the contractor does what he claims to do, but assuming he can, and I think he definitely can, well, yeah, you tell the guy, we don't like that one, change it. And that's what we do right now. What the legislature has to do is this real weird task. It has to write down every single molecular permutation that could possibly ever happen. From this, which is a litigable fact, which ends in a motion to dismiss, to me killing you, which is also a litigable fact and ends up being an electric chair. It's got to inventory all of those. There's not enough paper in the world. So ex-ante lawmaking only gets so far. So the courts do all this ex-post lawmaking. You bring the facts to us, we'll do it one by one by one. And that's fine, but it's not predictable. All the system does with the Judge.ai is that it makes that ex-post process, as much as it possibly can, also an ex-ante process. And what about grievous ambiguity? I mean, that is exactly what we're trying to go against. It's flagellation thesis. If it's grievously wrong, what is the court going to end up writing at the end? A more specific statute. They're going to amend the statute. Let's call it what it is. That's what that is. If that existed in the ether, well, textualism already said we're going to flog them into writing that in the first instance. And if we can actually, why flog them into writing with better English? Why not just flog them into using the binary language in the first instance? And that's why AI is cool. It's a self-translating language. How does that work? There's a billion papers that need to be written on it. Brian Garner probably needs to co-write half of. Linguists. How do we make sure the thing consistently adapts zeros and ones?
You're going to have the final word?
Yeah, sorry, yeah.
No, do you want
No?
We got other questions?
I
mean,
you right there. You've been...
What's our timeline?
Hang on.
Yeah.
Hang
You know,
on.
5 minutes or
okay.
That question, by the way, that's an excellent question because I think it's the one reason why we're not getting to judge AI anytime soon, in my mind. Mm-hmm. It's a question about bias in these models, and what people don't understand is there's human input into the models. There are value judgments that humans make. They want to program the model to not tell you how to make a bomb. Somebody decided that making a bomb is bad, and told Claude, don't tell anybody how to do that. That person is going to decide what this judge model is going to look like. And so we're just going to get back to policy debates about, are we textualists, or are there moral values? Are we natural lawyers? Are we positivists? We can program these. Judge AI we can use Rawls' theory of justice, or we could use Dworkin's Law's Empire. I don't know why we would, but we might. I mean, right? So we could make those choices.
But it's a salesmanship point.
But the problem, of course, is that human judges are also, we get criticized all the time, right? We're biased. We have subconscious bias. We decide cases based on, our upbringing and whatnot. And so that's a problem no matter what. Right. I mean, this is the one thing I always talk about when I talk about AI is when we can sit here and shit on AI and say it's not that great. But you're always comparing it to, you're not comparing AI to God. You're comparing AI to us. And so that, in Jack's hand movements.
I like that he's doing it. I got him doing it.
Are you faster than the slowest member of the herd if you're AI? Are you better or cheaper than we are? That's the interesting question. Right?
And it's a sales question, very briefly. I mean, that's why you base it on a predictor model that predicts what actual courts do. You can at least say, look, use my model because it gets exactly what the court's going to. If you don't like it, you're already stuck with that. That's brief. You had a question, right?
So one question I have is, obviously now, if it's going to become so fact dependent, we know that we have more access to information, statistics, photography, videos than ever, but so much of it now is incredulous. I mean, there's deep fake technology, there's an excess of information, but there's a dearth of reliability. And in that scenario, it would seem that what you primarily need is judgment in order to discern the truth of those things. And my concern is that I don't know how we can conceptualize AI's ability to use judgment. So what does that look like in this type of AI system?
Well, I mean, what you're describing might ultimately become a thing that only a bot can judge. Right now, you see the sixth finger, and you're like, got it. Well, it's not going to have a sixth finger for very long, and then you got to be looking for really nuanced stuff. And I don't trust myself. I got bad eyes. I'm not going to look at. He's got glasses, for God's sake. I mean, he's not going to. So do you. Shit. None of you guys are going to be able to do this. Like, I need a thing that can look at a pixel and like that pixel's out of place. It's not right. You need to like watermark these things. That's the most automatable part of this. I jumping around. Yeah. Oh, yeah. Back to you.
Yeah, I mean, I'm part of the originalism center thing here. So
Still? After this talk?
So help me out for saying this, but there is a lot of construction zone in constitutional litigation. You're either deciding like, hey, in appellate, you're either deciding, hey, we have this rule, we're going to extend it to this scenario or not this scenario, or for sake like Rahimi, we're going to look at the historical method of regulating firearms and decide, is this Texas statute close enough to when they used to disarm people who threaten people or something like that. Those are a lot of there aren't right answers. There aren't like clear cut. You're deciding to extend something to some other scenario, or using analogical reasoning and saying this is close enough to this. And there's not. I think to your point, you're making normative choices in how you do that. So if you're gonna have a program do it, it's gonna do it in some specific way and say, hey, we're gonna have X, Y, and Z. Yeah. We're gonna extend the scenario if it meets X, Y, and Z criteria or something like that. Or we should get like Article 3 programmers, but I don't see a lot of like federal appellate judges or Supreme Court judges going along with.
Well, there are judges in this room who have publicly admitted to having conversations with Claude. So
I'm not suggesting you wouldn't use AI.
You're another one?
If you're talking about, all right, are we going to extend like a specific doctrine that our circuit has used to some new scenario? This is an issue that hasn't been presented before.
Well, this is the problem with
originalism.
originalism.
First issue. I mean, like that's. Like you're either whoever's making that choice of how the program's going to come out X, Y, or Z way, and that's what we're going to be fighting over. So I think at what point do you get? How are you going to get buy-in from judges if they don't agree on anything in the first place? If we have two parties who hate each other and have different legal philosophies.
I mean, what you're describing is policy, and that's what everybody kind of realizes at the end of the day is like, yeah, there's no. It's then is this thing of the subjectivity because like. I don't know. It's picking at your friends in the crowd. We all know the Supreme Court does policy. That's why the FedSoc can get a little goofy at times. And if we're going to do policy, the question becomes like, all right, either we have to stop chimping when people talk about the junior associate model like Breyer does, or we have to give this to a different branch. Everybody always complains about the critarchy. You're describing a critarchy. You know, why was abortion not done the way women's voting rights were done? Why was that an amendment and the other one's a court case? It's all these FedSoc debates going down. You've hit it on the head. It's policy, which is weird then that when you go to the originalism seminar, nobody talks about policy. You'll get laughed out of them. Solon will hit you on the head with a brick if you try that. Believe me, I have tried it. You got to talk about, well, no, it is fixed. We're going to use the history, and we're going to go Control F, and it's fixed in time. You've hit it on the head. It's not fixed in time. It's policy. That's what animates constitutional law.
Yeah, but how does AI do policy? And that's what I'm missing here is you have to get a model that judges, that has enough support from the entire judiciary to, both large legal movements in this country to make these choices. I mean, what are they going to do? Originalism? Going to do living constitutionalism?
Well, I could talk your ear off about how I've convinced the James Wilson Institute to start making a morality bot. I finally convinced them. Hadley Argus gave in. They're going to try doing it, enumerate the actual moralities here. But I think at bottom, what you're realizing is it is policy, and if we do want people to be able to vote on this, we got to think of something. At some point, the SCOTUS just needs to have a morality so that people can know, oh, there is a right or there isn't a right to abortion. Let's change that. Right now, even if when Roe comes down, nobody's sitting there thinking, well, let's make some law here. They immediately go, let's wage a 30-year campaign to get our guys on the court and change that ruling. Notwithstanding what the public consensus is, nobody fights actual battles of public opinion anymore, which is what you probably should. That's why the left wins so much. They do that. But we get out here and we think, no, we're just going to use that court yet again. If we're talking about policy, let's just get out in the open and try to win some hearts and minds here.
So we'll be effectively electing the AI LLM model that will be making Supreme Court decisions.
It'd be nice if we did. What we're going to do accidentally, what's your name? Alex. What we're going to do accidentally, Alex, they're just going to start using GPT and Claude, like they're sort of already stumbled into because they're available. And somebody, maybe he's going to write a law review article that says, there's 3 U.S. constitutions. Jeez, now we got to run inventory. Who's using Grok? Who's using Claude? And then we're going to go, shit, I wish we had just enumerated one bot from the start. Because what does that bot think? That is a legislative decision. That's the fundamental basis of legislative decisions. And if the people get to vote on that, I think that is kind of extending the democracy to where at least this room, the Federal Society, claims it should be.
You want to do closing statements, final remarks?
I'm good if you want to. Wrap this up?
We can wrap it up. Here's the last thing.
You go, then I'll go. Okay.
Who's the biggest investor in the Federal Society? They never like it when I say this. People don't know this. People like the Koch brothers. It's Google. People don't know this. That's the big deal that Leonard Leo cuts. Google. You got to wonder yourself, like, what the hell were they doing investing in that? Like, it's kind of a left-leaning company. Did they get some antitrust out of it? I don't know. I don't know that the FedSoc revolution has been a moral one. Seems like more people like gay marriage, like abortion, etc., than ever before. But what did the revolution do? Well, it made judges, it's Atlantic Kagan. We are all textualists now. It certainly made judges more robotic. It put the control F-ing method. That's what every law firm has to do now. It got it much more in terms of tranches and searching and fixture. And Google makes robots. If I look at it from that angle, shit, I think they got an awful lot out of their investment. And I think when you consider the textualist quandary, you want to keep that top of mind. That's my closure.
I will just, I will say, look, the legal profession is still full of opportunity out there. It's changing like anything else. Be on the front end of it. If you're going to go in corporate, you figure out how to economize. There's going to be efficiency gains. I think corporate's already much more profitable than litigation. It'll get even more profitable as the firms that know how to use AI tech and can leverage that. Be one of those people that cashes in. If you're going to go litigation, figure out how to use the vault now. Good luck.
Buy facts. Buy and command facts.
Right. Thank you. You too? Good job. Thanks. Are you coming to dinner?
Yeah.
All right. Where are we going? Yeah, thanks.
Always fun, we have to leave the dinner a bit early.
Oh, you. Oh, yeah.
She's rising up.
Hey, Louie. How was that, man?
Yeah, it's good.
That was amazing.
Appreciate you having us out.